Welcome to The Explainer. So today we're diving straight into a really fascinating modern-day David versus Goliath story. We're going to see how a seemingly dry paper trail transforms into a gripping, high-stakes civil rights procedural. It's a super compelling look at how local government actually operates, how bureaucratic friction works, and honestly, most importantly, how a single, incredibly determined citizen can leverage public records and the legal system to demand accountability. So here's our roadmap for today. We'll start with Chapter 1, a citizen banned, then move right into Chapter 2, the pro se lawsuit. After that, Chapter 3, demanding public records, followed by Chapter 4, stonewalled by the police. Then things get really interesting in Chapter 5, the voting rights twist. And finally, we'll wrap it all up with Chapter 6, fighting City Hall. All right, let's jump right into Chapter 1, a citizen banned. You've really got to see the raw nature of this document. We're looking at a handwritten complaint dated May 5th, 2026. It was filed by a man named Dylan Thompson against the city of Newburyport, Massachusetts. He lays it out very clearly. He's been banned from the Newburyport Public Library for months. He claims that the no trespass order keeping him out is unlawful, invalid, overbroad, and basically completely unenforceable without authority or due process. It's simple, it's incredibly direct, and it's the exact spark that lights this entire fire. Now, to fully appreciate what's happening here, we really need to talk about the term pro se. Essentially, this just means representing yourself in court without the help of a lawyer. Dylan Thompson, he isn't backed by some high-priced corporate law firm. He is taking on a municipal Goliath entirely on his own. And honestly, that makes his upcoming legal maneuvers so much more fascinating to watch. Which brings us right into Chapter 2, the pro se lawsuit. This is a brilliant example of how accessible the courts can actually be, if you just know how to navigate the paperwork. Take a look at the formal civil action cover sheet. Down at the bottom, Thompson checks the boxes saying he's seeking declaratory and injunctive relief. But crucially, he writes no money damages sought. He literally just wants the ban lifted. And because he's representing himself and filed an indigency application, the court actually granted a fee waiver. The clerk waived the filing fee, the surcharge, the summons, and the service of process fees. He has officially launched a formal lawsuit absolutely for free. And that leads us to this incredibly imposing document, a formal court summons. Once filed, the Essex Superior Court issued this summons directed squarely at the city of Newburyport for docket number 2677 CV00548. Look at that bold text. The city now has a strict 20-day deadline to respond to Thompson's lawsuit in writing. So suddenly, this isn't just a disgruntled patron arguing at the library counter anymore. This is a serious, formal legal battle. Moving on to Chapter 3, demanding public records. So instead of just sitting around waiting for a legal response, Thompson immediately opens up a second front. He doesn't rely on just one mechanism. Step 1 was the Superior Court lawsuit to force judicial review. Step 2 was filing massive blanket Freedom of Information Act, or FOIA requests, to gather evidence. And Step 3? Keeping the ACLU right in his back pocket. It's a brilliantly escalating, multi-pronged strategy, perfectly designed to corner City Hall. You really just have to marvel at the sheer volume and precision of these public records requests. He submitted them on June 17th through the city's portal, specifically targeting the library and the police department. And he isn't just asking for a couple of emails. No, he is demanding every single incident report, staff communication, trespass notice, body-worn camera footage, and administrative decision relating to his ban, going all the way back from January 2021 to the present. He's casting an incredibly wide net to uncover exactly who authorized his exclusion and why. Let's take a quick look at just how fast this paper war escalates. May 5th, the lawsuit is filed. June 17th, he drops those massive records requests. Barely 2 weeks later, on July 1st, the police deny his request. By July 3rd, he has already appeared to the state level. And by July 5th, he brings in the ACLU. This timeline is wild. It perfectly highlights a citizen relentlessly keeping the pressure on a municipal government. That brings us to Chapter 4, stonewalled by the police. Okay, so here is the core legal clash of this whole situation. On one side, you have the citizen's right under Massachusetts General Law, Chapter 66, which guarantees public records and government transparency. But on the flip side, the police push back using a very specific exemption, 950 CMR 32.08. This rule basically allows the government to withhold records if they are the subject of active litigation. Essentially, because Thompson sued them first, the police are arguing, hey, we don't have to hand over these documents through the public records process. And here is what that denial actually looks like in practice. On July 1st, Senior Lieutenant Richard Siamosko of the Newburyport Police Department sends this email. He effectively stonewalls the request. He explicitly cites the ongoing Superior Court lawsuit, docket number 2067-700548, as the reason for withholding the materials. So the city is literally using his own lawsuit as a shield against transparency. But, as you might guess, Thompson absolutely refuses to take no for an answer. The very next day, he drafts a formal appeal directly to the Massachusetts Supervisor of Records, arguing that the city completely failed to provide a proper response. And then you see the rapid state acknowledgement on July 3rd from the Office of the Secretary of the Commonwealth. In the blink of an eye, he has escalated a local police denial into a full-blown state-level administrative review. And now for Chapter 5, the voting rights twist. Get ready, because here is a twist that reframes this entire dispute. Just listen to this quote. I need a lawful voting access procedure so I can vote without violating or being accused of violating any restriction. Wow, that completely changes everything, right? This isn't just about borrowing books or hanging out in the library lobby anymore. The building he is banned from is tied to his civic access. This is fundamentally about a citizen's constitutional right to vote. Because of this huge constitutional implication, Thompson plays his absolute ace card by filling out a July 5th ACLU intake form. He reaches right out to the American Civil Liberties Union, detailing all the events and explicitly tying the library's no trespass order to a very genuine fear. He is terrified of being arrested or charged with trespassing simply for trying to cast his ballot. Let's look a little closer at his plea to the ACLU here. He officially requests them to review this as an urgent voting access and civil liberties issue. He is specifically asking for guidance or a referral to force the city of Newburyport to provide a written voting-only access procedure. He's basically using the ACLU's massive institutional weight to make sure his civil rights aren't just crushed by some local administrative ban. Which brings us to our final chapter, Chapter 6, Fighting City Hall. Just think about how a single citizen managed to leverage the system here. He built an entire arsenal completely without a lawyer. He launched a pro se Superior Court lawsuit to establish judicial oversight. He wielded public records law requests to aggressively hunt for evidence. When he got denied, he bypassed local authorities entirely with appeals to the Secretary of the Commonwealth. And when he realized his voting rights were at risk, he escalated straight to a civil liberties intervention via the ACLU. And this final document from his ACLU intake form shows the complete web of accountability that Thompson spun. In one neat little box, he lists out his active Superior Court civil case right alongside 3 distinct public records appeals, SPR 26/2515, 2516, and 2517. These concern the library, the city clerk, and the police department. It is a fully documented multi-agency siege demanding transparency and due process. So, as we wrap up this explainer on the incredible power of civic documentation, I want to leave you with a pretty provocative question. Just look at the immense effort, the deep knowledge of the law, and the sheer tenacity required by Dylan Thompson just to fight a single municipal ban. How far would you go, and what tools would you use to protect your fundamental rights if you woke up tomorrow and found yourself literally locked out of your own local government? It's a heavy thought for sure, but it truly shows why understanding the actual mechanics of our legal system matters so much. Keep learning, stay curious, and thank you so much for joining me for this explainer. You know, it usually starts small. In this case, it started with a simple ban from a local public library. But, as you'll see, it definitely didn't stay that way. It evolved, and rather quickly, into a full-blown battle over the right to vote. Welcome to today's explainer, where we're going to track this seemingly minor local dispute as it escalates into a multi-front legal battle involving government transparency, complex administrative law, and our most fundamental civil liberties. We're getting an inside look at exactly how a citizen navigates the system. So let's dive into our focus for today, the escalation ladder from public library to civil rights. We're going to see exactly how a localized friction point transforms into a high-stakes constitutional question. Kicking things off with Phase 1, the library ban lawsuit. Okay, let's jump right into this. On May 5th, 2026, a self-represented plaintiff named Dylan Edward Thompson filed a handwritten complaint in Essex Superior Court. He's officially challenging a no trespass order that excluded him from the Newburyport Public Library. He alleges the order is, quote, unlawful, invalid, overbroad, unenforceable, and lacks due process. It's just a very raw, direct challenge to municipal authority. Now, you might be wondering what he's actually after here. Crucially, Thompson isn't looking for a payout. He's seeking what's called declaratory and injunctive relief. Basically, that means he's asking the judge to officially declare his rights and force the city to lift the ban. It's a purely principle-based legal maneuver aimed at restoring his access. But here is where it gets interesting, because the case's tracking order brilliantly illustrates the painfully slow crawl of justice. Thompson filed this urgent complaint in May of 2026, right? Well, the final pretrial conference isn't scheduled until October 2028, and the absolute deadline for a judgment is all the way out in May 2029. That is a staggering 3-year wait just to resolve a dispute over access to a public library. Which brings us to Phase 2, the public records dragnet. Faced with the 3-year wait for a court ruling, a plaintiff trying to build a case rarely just sits on their hands. And Thompson definitely didn't. On June 17, 2026, he launched a massive information gathering campaign. He didn't just ask the library for his own file. No, he targeted 7 separate municipal departments. We're talking the mayor's office, the city clerk, the city solicitor, the city council, the police department, the public library, and the library trustees. He wanted every communication, policy, and order related to his exclusion, dating all the way back to January 1, 2021. It is just a staggering amount of administrative data to request. Through the city's online portal, Thompson submitted these exhaustive, highly detailed public records requests. He's asking for incident reports, dispatch records, body-worn camera footage, internal memoranda, legal opinions, and even the city charter. Leaving absolutely no stone unturned, he essentially demanded the local government produce every single scrap of paper related to his no trespass order. And that leads us to Phase 3, institutional pushback and appeals. Well, it didn't take long for the pushback to arrive. On July 1st, just a couple of weeks after that massive request, an email comes in from Senior Lieutenant Richard Ciamasco of the Newburyport Police Department. And he writes, "I'm required by law to deny your request." His justification? He actually cites an exemption regarding active litigation, noting the pending Essex County Superior Court case. This perfectly and impartially demonstrates how institutions operate. The police department utilized the fact that Thompson sued them as the very legal basis to deny him the records he wanted for that exact lawsuit. So, if your request is denied by the local police, what's your next move? You don't give up. You escalate. You follow the administrative remedy. Step 1 is that denial by the local agency, which we just saw. Step 2 is filing a formal written appeal, not to the city, but up to the state, specifically the supervisor of records. And step 3 is waiting for the state to issue a binding determination. It's a highly structured mechanism designed to turn a local friction point into a matter for higher state-level review. And literally just 2 days after the police denial, the state's Public Records Division stepped in. On July 3rd, they sent an email directly to the Newburyport Police acknowledging Thompson's appeal and demanding a determination within 10 business days. This is the real-world mechanics of accountability in action, a higher state authority demanding answers from a local municipality. All right, moving into the final and most intense stage. Phase 4, the voting rights escalation. This whole situation forces us to ask a pretty profound question. What happens when a municipal ban collides with a constitutional right? Because, think about it, a no trespass order is a simple property restriction. But public buildings aren't just for reading books, they're the epicenters of civic life. If you're banned from a public building, and that building just so happens to be your designated polling place, what happens to your right to vote? Now, what's really interesting here is how Thompson addressed that exact fear in an ACLU intake form filed in early July 2026. By officially bringing in one of the nation's largest civil rights organizations, the nature of his complaint shifts entirely. He's no longer just asking for library access. He's urgently requesting legal help to navigate an upcoming election without risking an arrest for trespassing. In his ACLU request, he literally writes, "I need a lawful voting access procedure so I can vote without violating or being accused of violating any restriction." This fear really underscores the macro concept at stake here. Without written clearance, simply exercising his democratic right could result in criminal charges. Which leaves us with this final, incredibly important question to ponder. how do we balance a municipality's authority to restrict access to public property with a citizen's unalienable right to participate in democracy? What starts as a localized dispute over library rules can rapidly expose the fragile intersections of our legal and civic systems. It's a powerful reminder that in the realm of civil liberties, no local bureaucratic decision exists in a vacuum. Thank you so much for joining me for this explainer, and keep asking the hard questions about how our systems operate. Okay, let's just dive right into this explainer. Today, we're going to untangle a really fascinating municipal legal dispute. It shows us exactly what happens when a single, seemingly simple building ban triggers this massive cascade of lawsuits, public records requests, and serious civil liberties questions. You know, we usually think of local government as just fixing potholes or managing budgets, but this situation, it perfectly illustrates how quickly a hyper-local restriction can spiral into a complex constitutional maze. We're going to break down the anatomy of this exact scenario, looking right at the primary source documents. We'll be breaking this whole web down through 5 key areas today. First, the library ban lawsuit. Second, the public records dragnet. Third, how being a litigant clashes with transparency rules. Fourth, escalating to state appeals. And finally, the voting access dilemma. Let's start with Section 1, the library ban lawsuit. All right, kicking things off on May 5th, 2026. A self-represented plaintiff, Dylan Edward Thompson, filed a civil action in Essex Superior Court against the city of Newburyport. In his handwritten complaint, he's seeking what's called declaratory and injunctive relief. Basically, he wants a judge to formally declare his rights and issue an order to stop a library no trespass ban. It's actually really fascinating to see this initiated without an attorney. It's literally just a citizen filling out the standard forms, checking the boxes for an equity action involving a municipality, and formally putting the city on notice. And this complaint, it really just gets right to the point. He lays out his constitutional claim without asking for a single dime in monetary damages. He's not looking for a payout here. He notes he's been banned for months, and he specifically challenges the authority and due process behind the restriction. This right here is a textbook legal challenge to municipal authority. I mean, who actually has the right to ban a citizen from a public building? And what kind of process is owed to that citizen before it even happens? But here is the harsh reality of the legal system. When we look at the court's tracking order for this case, it becomes super clear that civil litigation is a marathon, not a sprint. The initial paperwork was filed in May 2026, right? Well, the final resolution judgment is scheduled all the way out in May 2029. That is 3 full years of waiting just for a judge to make a final call on whether this citizen can walk back into the public library. When you need immediate relief, a 3-year timeline is just a massive hurdle. Which brings us to Section 2, the public records dragnet. So because court cases take years, our plaintiff decided to use a parallel administrative strategy next. Basically, if you can't get a judge to act right away, you can at least try to gather every single piece of evidence available. In mid-June 2026, about 6 weeks after filing the lawsuit, he turned to the city's transparency tool, the Next Request web portal, to start digging. This is such a great example of how citizens interface with local governments these days. It's this online dashboard where you can submit public records requests, track them, and actually see which departments have been assigned to gather your documents. In this particular case, the request was routed to IT, the library, the mayor's office, and the police. The really crucial takeaway here is that the scope of these requests was absolutely massive. He didn't just ask for a copy of his ban. No, he demanded over 5 years of communications, internal memos, and policies across all these different city departments. He wanted everything from police dispatch records and body cam footage to library trustee meeting minutes and legal opinions from the city solicitor. It's essentially a comprehensive dragnet designed to pull up literally any internal discussions about him, along with the overarching policies the city uses to issue these trespass warrants in the first place. Moving on to Section 3, litigant versus transparency rules. Now, this brings us to a super interesting friction point. What actually happens when you sue a city and then turn around and ask that exact same city for their internal documents? Well, it creates an incredible administrative collision. On July 1st, the Newburyport Police Department just flatly denied the records request in an email. The senior lieutenant wrote that he reviewed the materials, but his hands were tied. He was legally required to deny the request, specifically pointing to the active Essex County Superior Court case. What's really fascinating here is the specific legal exemption they cited, 950 CMR 32.08. Essentially, this state rule means an agency can legally withhold public records if they are currently fighting the requester in court over those exact materials. It creates this wild catch-22 for citizens. On one hand, you have a right to sue the government. On the other, you have a right to request public records. But if you try to do both at the exact same time, the lawsuit itself can actually be used as a shield by the government to block your records request outside of formal court discovery. Let's look at Section 4, escalating to state appeals. So when that local municipal door slams shut, the next logical lever to pull is the state-level appeal. Here's how this builds. The plaintiff escalated the matter by taking his initial Freedom of Information Act requests and appealing the city's non-responses, as well as that explicit denial from the police, directly to the Massachusetts Supervisor of Records. This is pretty much standard operating procedure for public records disputes. You start local, and if they say no or just completely ignore you, you kick it up to the state level and ask an administrative body to force the municipality's hand. And here is exactly why that state appeal is such a powerful tool. Once an appeal is officially acknowledged, the state is locked into a strict statutory deadline of just 10 business days to issue a determination. Think about that. It completely circumvents that agonizing 3-year court timeline we looked at earlier. It puts the city's transparency compliance back on a very fast, very aggressive clock. As we can see in this July 3rd acknowledgement from the Public Records Division, the state's bureaucratic machinery was officially in motion. The state notified the local police department that an appeal had been filed and firmly reminded them that the supervisor of records must issue a determination within 10 business days. So suddenly, the local police department isn't just brushing off a frustrated citizen anymore. They actually have to answer to the state government. And finally, Section 5, the voting access dilemma. All right, let's look at how a localized municipal property dispute suddenly blows up into a fundamental constitutional issue. Just 2 days after filing those public records appeals, on July 5th, the plaintiff submitted an urgent intake form to the ACLU of Massachusetts. He filled out their online questionnaire detailing his pending civil case and the records appeals. He notes that he isn't currently represented by a lawyer, and he's reaching out for some highly specific constitutional assistance. This intake form reveals the true stakes of this entire explainer. The plaintiff writes, "I am not seeking general library access. I need a lawful voting access procedure so I can vote without violating or being accused of violating any restriction." He's asking for guidance to ensure the city provides a written voting-only access procedure so he can cast his ballot without risking arrest for trespassing. Because, municipal buildings like libraries and city halls frequently serve as polling locations. So a blanket trespass order suddenly threatens a citizen's fundamental right to participate in an election. And this just brilliantly illustrates how local administrative actions, like a standard municipal building trespass order, can inadvertently collide head-on with fundamental democratic rights. Sure, a library ban might seem totally straightforward on a random Tuesday in May, but on Election Day, if that library happens to be a polling place, that local ban effectively becomes a disenfranchisement tool, unless they make a specific carve-out for voting access. It really leaves us with this provocative question about the balance of local government power versus civil rights. How exactly should municipalities manage safety and property restrictions without inadvertently stripping citizens of their constitutional right to vote? As this complex web of lawsuits and records appeals slowly grinds toward that distant 2029 court date, it's a stark reminder that even the most routine local administrative decisions can have profound constitutional ripple effects. Keep this dynamic in mind the next time you see a local dispute unfold in your own town. Thanks so much for joining me on this explainer.